The Mad Hatter here with part 22 of the My Docket series on Corazon real estate. Almost caught up. Two more videos of the Mad Hatter. So we have the motion to strike. But really, it's more of an opposition to my motion for costs. And so, I'll talk about that more when I get into the document. My mindset was definitely annoyed. Every time I see a motion to strike from an attorney, I just get irritated. Unless they're trying to strike a pleading. If they're trying to strike a pleading, fine. That makes sense. It's logical. But using motions to strike motions to strike oppositions, it's just a massive headache because of the timelines and the deadlines for briefing. The Supreme Court of Nevada has filed at least one opinion saying that it's annoying to them when somebody tries to file a motion to strike a motion. Striking a request for submission, which is what they're trying to do, I feel like it's the same thing. Just mention it in your opposition. Just mention it in your opposition. Just say in the opposition, this is not untimely. Please consider the opposition. Instead, they file motions to strike. It's like, I don't know. Part of me thinks they're just trying to bill more. In any event, that's my my soapbox on motions to strike. They're filed, I think, way too often. I think they're irritating, with the exception of trying to strike a pleading. Trying to strike a pleading makes sense. There is logic behind doing at least that. I wonder if I have a video on the topic motion to strike. Because if I do, I'd probably talk about that. And in the event, mindset, probably very annoyed. And that's all I can really recall by reading just the title of this document. Because, even all these years later, I get annoyed when I see one of these. So yeah, that's going to be everything for the mindset portion. Let's go straight into what Katherine Parks has filed. Here we have Katherine Parks' motion to strike and or opposition to plaintiff's motion for imposition of costs on appeal. This one is not as bad as most. Just the fact that she has and or and that there's an opposition here. At least she's trying to not be annoying. It's still kind of confusing because the deadlines are different. The deadline for a motion is different for the deadline of an opposition. So now what am I supposed to do? Am I supposed to file an opposition / reply? Do I file that separately? Do I file one opposition to motion to strike and then also a reply to opposition? There's actually a rule. There's a local rule that says not to do this. So it's not even complying with the Washoe County District Court rules. It's one of the rules way up in the beginning. The only thing that they will let you combine is a motion with a request for alternative relief. They do not want you to file a motion combined with an opposition in Washoe County. In District 8, Clark County, they actually do allow this. They call it a counter motion. I believe that's what they call it. They let you file an opposition and counter motion. I think that's what it's called. In any event, Washoe County, not supposed to do it, but some attorneys do it anyway, and they get away with it typically, which is fine. Going into the document, we have standard introductory paragraph. Defendant Corazon Real Estate buying through its attorneys, moving to strike the request for submission and or deny the request relief. The relief requested in the motion to require them to pay the cost of the filing fees to the court. Introduction. Case arises out of a former landlord-tenant relationship. I'm acting in proper person. I was the tenant. Motion to dismiss was filed by Charles Chinichi. I opposed the motion. Motion was granted. I filed a notice of appeal. I filed a motion to get the fee waiver on the appeal. The 3-judge panel reversed the decision. Before the remitter issued, I filed a motion which seeks this court require the defendant to pay to the court the sum of $250. It's the amount that I would have been required to pay had I not been granted forma pauperis privileges. She characterizes this very accurately. This is all very true. Okay, this part's not, though. The motion are procedurally and substantively improper. They should be denied. Why, though? The motion must be denied as the court lacked jurisdiction over the case at the time of its filing? What? Oh, this isn't really true. The court can't enter an order. It's true that the court can't enter an order, but it's not true that you can't file a motion pending. Oh my gosh. With this attorney, I don't know if she's just trying to dupe the court or if she actually doesn't know, because this does confuse a lot of attorneys. So yeah, I talk about this in the video, jurisdiction divested on appeal. It's true that the court cannot enter anything while jurisdiction is divested, but it's not true that a party can't file things. And the reason why is actually talked about in the video, jurisdiction divested on appeal. The reason why is because you can ask the court to do certain things while it has been, there goes the hat, while jurisdiction has been divested on appeal. For example, you can ask the court to make a ruling on an issue that is not one of the issues that is on appeal. So that you can do. And you can also ask the court to do something on an issue that is on appeal. You just have to follow something known as the honeycut procedure. And if you're going to have to file things in the lower court, even though there's no jurisdiction, pending some kind of ruling from the higher court. So she's wrong that you can't do this for multiple different reasons. If you want to learn more about the honeycut procedure and all those other complexities, watch my video on the topic, jurisdiction divested on appeal. So the defendant's failure to oppose it within 10 days does not constitute an admission that the motion has any merit, which isn't true. She's wrong because of DCR 13. The actions in filing a request to submit the motion 1 day after remitter was issued must be granted based on the failure to oppose same. So a lot of legal mumbo jumbo, but I mean, it would be one thing if she was right. She's just not. The requested defendant has been required to pay costs pursuant to 12.015 has to be denied. The gist of the motion is that I was not required to pay a filing fee, and that the court should impose a filing fee on the defendant pursuant to 12.015. The request has no support in Nevada law. 12.015 contains statutory authority by which the court can grant an indigent person the right to proceed in form of paupers. Subsection 4 provides that if the person prevails in the action, the court shall enter its order requiring the losing party to pay within 5 days the costs that would have been incurred, and those costs must be paid as provided by law. The Supreme Court has held that proper privileges are provided by statute only for the trial level of litigation, not for appeals. Further, plaintiff is far from the prevailing party in this litigation. Interesting. She might be right about this. Casper versus Huber. Usually I won't do this, guys, but I'm going to go ahead and take a look at this. Casper versus Huber. Basically, she's saying that the authority for the fee waiver comes from the Supreme Court, not the lower court. Where is 12.015, though? It's footnote 3. There is no statutory authority for either requests. Pauper privileges are provided by statute only for the trial level of litigation, not for appeals. So if the authority for the fee waiver comes from statute, okay, they're saying that their inherent powers allow them to waive the filing fee. So they draw on their inherent powers to allow you to waive your filing fee in the Supreme Court. But that this does not come from a statute. It comes from their inherent powers. Let's take a look at 12.015. I'm very curious about this. Any person who desires to prosecute or defend a civil action. Well, it says civil action. It doesn't say appellate action. You know what? This is a good argument. She might be right. She might be right that because the authority comes from the Supreme Court's inherent powers and not from 12.015, if the person prevails in the action, the court shall enter. Okay, yeah, I think the attorney's right. I think that the attorney is right about this, because subsection 4 is the subsection that allows the losing part, or that requires the losing party to pay the costs. And this is referencing if the person prevails in the action, and it's referencing civil action. And this is an appellate action, and the authority to file the fee waiver comes from the Supreme Court's inherent powers, not from 12.015. Okay, I think that the attorney's probably right about this. It makes sense. I'm not 100%, but I'm leaning towards the attorney being correct. That because it's a Supreme Court appeal, and because the fees were waived by the Supreme Court not using the statute, but by using their inherent powers, that it would follow logically that the subsection that requires the losing party to pay does not apply. This makes sense to me. It's a good argument. Certificate of service under Rule 5B indicating this document was mailed to me. Going into the aftermath, I didn't file anything, so I incurred $0 in costs. The attorney filed one document, but it's a free filing, so Corazon Real Estate incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. The attorney would have, it's hard to say they would have spent less than an hour. I mean, just to be nice, I almost said a half hour, but this would have taken some research. I'm going to go ahead and say an hour. And at the rate of $250 an hour, that's going to come to $250 in attorney fees for Corazon Real Estate. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.